much time do we have? Mr. Speaker, with your permission, I'll proceed from where my colleague Mudhomi has left. Honorable Mutuse, can you go to ground number 2 of your motion?
We'll be there shortly.
I think that's page 10 of volume 1.
Here we are.
Yes, what is the nature of this ground? What are you complaining about?
We are complaining that the Deputy President has on numerous occasions violated Article 147(1), as read together with Article 152(1) of the Constitution of Kenya. And in particular, Article 147(1) provides that the Deputy President shall be the principal assistant of the President and shall deputize for the President in the execution of the President's functions. While Article 152(1) of the Constitution states that the Deputy President is a member of the Cabinet. And in particular, through Cabinet communique, as you are aware, after every time there is a Cabinet meeting, there is normally a press release that is released. And we were aware of a decision of the Cabinet of the 30th of April 2024, where the Cabinet passed a resolution to evacuate members of the public for their own safety from the 30-meter riparian zone of the Nairobi River.
Yes.
And when that decision was made, insofar as I understand processing of business in the Cabinet, the Deputy President sat in Cabinet. The Deputy President is one who chairs Cabinet subcommittees which process business before going to Cabinet. And therefore, to my own understanding, he was fully involved in the making of that decision. However,
okay, just to cut you short because of time, the allegation is that the Deputy President has been undermining the President.
Yes.
Do you have evidence in your motion that support this allegation?
Yes, I have evidence.
Which evidence is this?
The evidence is in respect of the Cabinet resolution regarding the evacuation of the riparian, of the settlers around the riparian area, in that area, and our evidence is contained in the affidavit of Ms. Mercy Wanjau.
Where is this affidavit of Mercy Wanjau?
The affidavit of Mercy Wanjau is to be found on page 78 to 80 of volume 1.
Has the DP admitted these allegations?
Yes, the DP has admitted the allegation to say there was a Cabinet resolution, but he went against it.
Where is the admission contained for purpose of the answer? The admission by the Deputy President?
If you look at paragraphs 10.1.1 and 10.1.3 of the DP's response.
Yeah.
Volume and page.
Volume 6, page 19 of 534. Paragraph 10.1.1, he says as follows. The Office of the Deputy President has undertaken extensive engagement with all parties in regard to the Cabinet decision on eviction, which I fully support, including the Nairobi River, which is an entity under the ODP.
Okay. I think we can hold. We can stop there. So, yes. In your opinion, as the move of the motion, can the government of Kenya function if the Deputy President and the President are not reading from the same page?
It will be very difficult for the government to function and to deliver effectively to the people of Kenya when the two highest office holders are reading from different scripts, and especially when the Deputy President, for political expedience, would disown decisions of the Cabinet in a meeting that he sat through to make a decision.
Yeah, thank you very much. Now, you have you annexed any videos to prove this allegation?
Yes, indeed.
Video number?
We have annexed video number 10. Video number 10.
Video number 10.
And also video number 10.
What does video number 10, what is it all about?
Maybe they can play it for honorable senators to see for themselves.
Can you play video number 10 briefly? Mr. Speaker.
Watu ya Kayole, tangu mtupatie nafasi ya uongozi, sijapata nafasi ya kuja kusema asanti. Nataka kutoka kwa roho yangu, watu ya Kayole, asanteni sana. Mimi najua, nimeona iko shida ya watu ambaye walibomolewa, si ndio?
Maybe you can,
na nimeona mumeandika vizuri ya kwamba mteue kamati ya watu wachache ndio mkuje niketi na nyinyi. Utakubaliana? Mimi ningetaka wale watu ambaye walipata shida hii ya ubomoaji, ambaye ni kitu tulikuwa tumeahidi wananchi haitafanyika kwa serikali yetu, mimi ningetaka niwasikize na nitapanga na mheshimiwa Meja Dong wakuje ndio tukue na nafasi ya kuongea.
Let us not have a war with wananchi. Tusipigane na wananchi wale walituchagua. Let us be empathetic. Let us, if people must move, let there be an engagement and let people get adequate notice so that they can prepare for their next life ahead. You can't wake up one morning and terminate people's life. Let us not have a...
Mr. Speaker, sir, we can stop there because of time. The video has been submitted as part of the evidence from the National Assembly. Honorable Mutuse, let's go to ground number, allegation number 3. Ground number 3, very quickly. What is it all about? What is your complaint in the Senate? In ground number 3.
Our complaint to the Senate is that the Deputy President has undermined devolution.
Why do you say so? Briefly.
We say so because there was a lawful decision by the City County of Nairobi about...
Which is this lawful decision? You can be specific.
The City County of Nairobi did make a resolution,
yes,
to relocate traders from CBD to Kangundo Road. And the Deputy President, through evidence that we have...
Is that decision to relocate traders a county government function?
Yes, and Senate, because it is a house that is created under Article 96 to protect the interests of counties, would take notice that markets under Schedule 4 is an exclusive function of counties.
Yes. Have you submitted any video evidence to support this allegation that the Deputy President has undermined the devolved government system, especially the county government of Nairobi?
Yes, video 12 and video 13, where members of the Senate shortly will see that the Deputy President went to Wakulima Market and incited members of the public not to obey lawful directives of the City County of Nairobi. We have also, as part of our evidence, annexed the sworn affidavit of Mr. Johnson Sakaja, the governor of Nairobi, with averments to that effect. This is at page 81 to 85 of our volume 1.
Okay, I think the video is part of the evidence. It's part of the record. So why do you complain about this in the Senate? Why are you complaining?
The senators want to see the video, want to hear, see and hear the video.
Can we play video 12?
Nairobi Governor Johnson Sakaja spearheaded for yet another round of an influence contest of the capital city, with the Deputy President putting the governor on notice over the alleged mistreatment of traders in the city. And as Citizen TV's Melita Olatengas reports, the latest rupture in the relations between the two have been compounded by the broader tribulations of Gachagua, who sees himself as being sidelined by the Kenya Kwanza State House.
2 years ago, downtown Nairobi, in the thick of the campaign trail, and fast forward to this on Friday. In the same style and fashion, he returned to Marikiti, heightening the standoff with Sakaja over traders' relocation. Gachagua says he made a promise that he holds dear, but the governor seems to be having a different vision for the county.
Mimi siwezi laumiwa ati watu ya mlima ni wengi hapa Marikiti, kwa sababu hiyo ni Mwenyezi Mungu aliamua. Na hao watu ya mlima wanasema walikuwa wengi, wakikupigia kura kwa nini ukulalamika ni wengi?
Nobody should imagine that they can micromanage the county of Nairobi from anywhere. No one should imagine that we will suspend devolution in Nairobi from anywhere.
A stop.
So Honorable Mutuse, is that act by the Deputy President impeachable?
It is impeachable in the sense that the two levels of government have been assigned their roles and their functions under Schedule 4 of the Constitution.
Yes.
And the Constitution and Article 6 requires that the two levels of government, much as they are interdependent, they also respect their functional independence. And that if the county government makes a decision, it is upon them to implement that decision. You would realize, much as Nairobi is the capital city of Kenya, cosmopolitan, when the Deputy President went there, he addressed Kenyans in his native language.
Is it compatible with the status of Deputy President to address these core issues at a marketplace like this?
It is not consistent. The expectation was that through the intergovernmental relations framework that is already established in law, there would have been a formula to deal with that issue outside the rally.
Which is this framework that you are talking about? The framework that you are talking about for intergovernmental relations, to be specific. Eh?
Well, we have the Intergovernmental Relations Act. And it will be expected that the Deputy President, being the chair of the Intergovernmental Relations Committee and also IBEC, would have exercised his responsibility under the law and those responsibilities,
yes,
to call a meeting with the City County of Nairobi to deliberate on those issues if indeed there were complaints from the citizens of Nairobi in a manner that is consistent with the formal running of a government.
Okay. I think because of time we can move to allegation number 4. Are you there? Just go to your motion, allegation number 4. What is it all about? Explain briefly to the honorable senators. Allegation number 4, I believe it's at page 14 of your motion.
1 minute. Yes, here we are. Now, our ground 4, Mr. Speaker and honorable senators, is gross violation of Article 161 of the Constitution, specifically undermining the institutional and decisional independence of judges.
Hold on, Honorable Mutuse. What do you understand by the word gross? You're using it in a context, and I think it is important you explain briefly. What do you understand by the meaning of the word gross?
My understanding of gross violation of the Constitution, I don't know whether I will be speaking in my knowledge as a lawyer or just as a...
Please give your opinion. What is gross? It goes into the answer there.
I think gross violation of the Constitution, the best would be found in the Wambora decision.
Okay.
The Wambora decision did define what gross violation of the Constitution means.
Yes.
And it is said it is the violation of Article 10, Article 1, and several articles of the Constitution. I do not have the particular citation, but to my mind, I think it's paragraph 46 of that decision.
Okay. So let's go back to allegation number 4, ground number 4. What is it that you're complaining about in this ground? In summary?
We are complaining that the Deputy President did threaten in a manner that displayed personal vendetta the person of Esther Maina, a judge of the High Court of Kenya, and the reason for threatening her with filing a motion, a petition for a removal from office, was particularly in relation to a decision that she made in a case that was involving the Deputy President by finding that assets to the tune of cash 202 million that were held in his company's accounts were proceeds of corruption and money laundering. And for making that decision, the Deputy President, against the provisions of Article 161, threatened the Justice Maina with corruption and with removal from office.
Yeah, this decision that you are talking about, Justice Maina's decision, where is it? You can point it out to the honorable senators. This decision, the judgment of Esther Maina.
Honorable Senators, Mr. Speaker, honorable senators, in our volume 2A, at page 62, at page 60, all the way to page 77, we have annexed the judgment of the Honorable Judge Esther Maina, where many of the companies that we have stated in the other allegations are listed here as companies that are conduits of corruption and money laundering.
Which companies are these in the judgment? Just maybe you can name a few of them so that we are more specific for the answer.
You have heard us talk about Crystal Kenya. Crystal Kenya is here.
You're saying Crystal Kenya is mentioned in the judgment?
Yes, this is on page 64. And many, many others. So that with Wanyama Investments, you have heard us mention Wanyama Investment. Wanyama is mentioned here several times.
So what is the conclusion by the judge in that judgment, the decision that you are complaining about?
The judge said that in the upshot, the originality motion is granted in terms of prayers 2. This is page 77 of 123 in our volume 2A. That a declaration is hereby issued that the following funds are proceeds of crime and therefore liable for forfeiture to the state. And they are listed there: 165 million held in a certain account at Rafiki Finance Bank, 35 million in the name of Rigathi Gachagua, 773,000.
How much in total did the judge find to be money that the Rigathi Gachagua at the time had obtained through proceeds of corruption?
That order is hereby issued that the above funds be forfeited to the government of Kenya and transferred to the Assets Recovery Agency, and the amount is about 200 million shillings.
So he finds Mr. Rigathi Gachagua to have obtained 200 million shillings, is that correct?
To have been unable to explain
200 million
how he obtained 200 million shillings.
What did the judge do after that finding?
The judge directed that the amounts be forfeited to the government of Kenya through the Asset Recovery Agency, which is the body created under the Proceeds of Crime and Money Laundering Act to take care of money laundering.
Yeah, Mr. Ongoya, for the Deputy President who was here, and the family stated that that you have no ground at all to bring this allegation in the Senate. What is your specific complaint in the Senate on this allegation?
My specific complaint is that when a judge in a functional democracy in a country of rule of law like ours, when a judge makes a finding against, and the judges make findings against all of us every day, the civil way of challenging that decision is through an appeal. So you appeal the decision. You do not go to a rally and start threatening judges, because then you create fear, and you create fear in the judges so that they are not able to exercise their decision or independence. You can interfere with financing of the judiciary. You can interfere with many, many other things. But let's not take away the decision or independence.
Honorable Mutuse, do you have any evidence that you've submitted to the Senate to prove this allegation of, you're calling it interference with the independence of the judiciary? Do you have any video evidence, any evidence?
Yes, I have presented video number 14 and video number 15.
I request the video, Mr. Speaker, to be
clips
Begin the bulletin with the war on the judiciary, where Kenya Kwanza administration is making good on its threat, with the Deputy President Rigathi Gachagua now filing a petition to push for the removal of a judge from office.
Gachagua says he will on Thursday file a petition with the Judicial Service Commission to push for the removal of Justice Esther Maina, who handled an economic crimes case against him in 2022 for alleged corruption and misconduct. Now, speaking in Iten, where he accompanied President William Ruto for a church service, Gachagua told the Chief Justice to first clean up her house by dealing with pending cases with the Judicial Service Commission. Now, in the sustained onslaught against the judiciary, President William Ruto vowed to deal with unnamed government officers he described as incompetent, saying his administration will slay the corruption monster that has reared its ugly head in various arms of government. Chamatai Goin reports.
After Chief Justice Martha Koome invited Kenyans with complaints over the conduct of judicial officers to submit their lamentations to her office, the Kenya Kwanza administration, through Deputy President Rigathi Gachagua, has taken the challenge, with the DP announcing that he will file a petition this week.
Amechallenge sisi tutoe ushahidi. I will lead by example. On Thursday, this coming week at 2:15, I will personally present a petition before Lady Chief Justice Martha Koome against Justice Esther Maina for her removal from the judiciary for misconduct and corruption. Mimi mwenyewe nitaongoza because sasa unajua sasa si ametuuliza. Sasa tuko tayari, mimi ndio nitaongoza kwa executive.
Gachagua reliving his July 2022 incident where 202 million shillings was seized to the state after Justice Esther Maina ruled the money was proceeds of corruption having been acquired through dubious means.
Huyo judge through corruption declared my hard-earned wealth proceeds of crime without giving me an opportunity to be heard. Against the rules of evidence, where he who alleges must prove. We made an application to cross-examine the investigator akakataa kwa sababu anajua there is no case. Na evidence tuko nayo vile ilifanyika.
The Kenya Kwanza Battalion hitting out at Koome for being quick to defend judicial officers, some of whom they claim were not beyond reproach.
I think we can stop there. We can stop there. Now, Honorable Mutuse, it looks like in this public forum, statements were generally made against the judiciary. Is that correct? By all politicians who attended?
Yes, it is correct that even others who were there made statements against the judiciary, and there is no problem with that.
So what is so extraordinary? Mr. Ongoya said, there's nothing extraordinary about your complaint.
My complaint is extraordinary in the sense that the Honorable Rigathi Gachagua was not complaining about the judiciary. He was complaining about a specific judge for a decision that she made, a finding that she made against him. It was not about corruption in the judiciary. It was not about inefficiency in the judiciary. It was not about how the judiciary runs. It was about huyu judge alisema mali yangu ni mali ya wizi.
Now, in that public statement, the Deputy President says he has evidence on corruption against Lady Justice Maina. In his response filed before this House, have you seen any evidence adduced for corruption against Lady Justice Esther Maina?
I have not seen any evidence to show that indeed he has evidence of corruption influencing the judge to make the finding that the 200 million were proceeds of crime.
Okay. Now this judgment
which leads me to my conclusion that this is personal vendetta.
What do you mean by personal vendetta?
Personal vendetta is you are here in Senate representing your people, you make decisions in Senate, you make debate in Senate as part of your constitutional mandate. You mention people who are not doing things right, and when you get out there, they threaten you. They tell you, when you say that again in Senate, I'll kill you.
Okay.
I'll get you removed from Senate, to create fear. Personal vendetta.
Now, this judgment, which you've said is available at page 60 to 77, and you quoted it of volume 2A of your documents. Could you by any chance know what happened to this judgment?
Yes, I am aware that Indeed, the Deputy President did appeal against that decision.
Yes.
But on becoming Deputy President, the same was settled through a consent, a compromise, as it would be, and the money was returned to him.
Money was returned to him. Have you seen this consent that was recorded at the Court of Appeal?
Yes, I am aware of the consent.
Okay, you are aware?
I am aware that the consent was not arrived based on the merits or demerits of the case.
Okay.
It was just government bodies, because leadership has changed hands, and the second in command now is powerful. A few government bodies, Asset Recovery Agency, they went to court and they said they want to withdraw.
Finally, Honorable Mutuse, is there a decision of the Court of Appeal? A decision of the Court of Appeal upsetting or setting aside this judgment and the finding by Lady Justice Esther Maina about
to my understanding, and the lawyers in the House will also have the same finding. There is no decision of the Court of Appeal.
Have you seen any of this response?
Overturning Justice Maina's decision, and therefore Justice Maina's decision remains good law.
You have come through the response by His Excellency regarding Gachagua. Have you seen any appeal decision setting aside?
No, there is
any order setting aside the judgment?
The consent is there, but there is no decision on merit from the Court of Appeal.
Okay. Honorable Mutuse, let's go to ground number 8, allegation number 8, and briefly explain to the...
Maybe before we leave there...
Yes.
It is important in terms of, because we are complaining about Article 160,
yeah,
for me to just read 165. A member of the judiciary is not liable in an action or suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function.
Okay.
Because that is a particular section we are complaining that the Deputy President has violated.
Has violated, okay. So in your opinion, does undermining the independence of the judiciary amount to gross violation of the Constitution?
Indeed, it amounts to gross violation of the Constitution. It will be, remember that we have three arms of government: the executive, the legislature where we sit, and the judiciary.
Is it proper for the Deputy President of the Republic of Kenya to make this kind of attacks? Is it proper in your opinion?
It is not proper at all.
Okay. And what, in your, again, to just wrap that point up, what channels...
Counsel, before you get there, you refer to a consent. Is it contained in any of these bundles? The senators would wish to look at that consent.
Honorable Mutuse, you said you have seen a consent. You are aware about it. Have you seen the consent?
It is not filed in our documents, but in my ordinary course of business, I am aware of the consent.
Okay.
If it becomes necessary, the Senate has the powers to recall it. In fact, it is a public document because it is reported under Kenya law reports.
Fair enough. Let's go to allegation number 8 because of time, so that we don't take a lot of time and finish our time. What is the substance of your allegation number 8? Briefly, ground number 8.
Ground number 8 is that there are serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 129 of the Leadership and Integrity Act. And basically here, it is on two folds. The two sections that we have cited, Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act, speak to state officers misleading the public, spreading falsehoods. And on the issue of Justice Maina, as we have shown evidence, it was personal vendetta because the Deputy President was attacking the judge based on a decision the judge had made. On the second one, in terms of the particulars, His Excellency Rigathi Gachagua recklessly and unmindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, as well as his membership to the National Security Council and Article 240 of the Constitution, both being positions that require one to be discreet and tempered especially during moments of national crisis, addressed Kenyans on live television in Mombasa County and publicly made sensational statements against the National Intelligence Service, an essential national security organ, its Director General and the officers.
And also, you can hold on there. Do you have evidence to prove these allegations about a live television statement in Mombasa by the Deputy President? Do you have any evidence before this House?
Yes, we have annexed our video number 15.
May I request we play video number 15, please, Mr. Speaker.
Where did the rain begin to beat us? Where did we stop listening to the people? President William Ruto and I were the darling of the Kenyan people. By listening to them, by engaging them. And as a government, we have established institutions to ensure we not only listen to Kenyans, but also genuinely understand their concerns. We invest significant resources in these institutions, particularly the National Intelligence Service, for this purpose. It is clear there has been a failure in the intelligence and advice we are receiving, particularly concerning crucial government policies. The President of the Republic of Kenya today has admitted that it has come to his attention that the people of Kenya did not want anything to do with the Finance Bill 2024.
Honorable Mutuse,
President,
maybe we can...
There is an important
okay. You
has now agreed that we need to listen to the people.
Yeah.
And I sympathize with my boss, President William Ruto, because this information was not available to him. I know President William Ruto. Had he known 2 months ago that the people of Kenya did not want anything to do with the Finance Bill 2024, he would not have asked his parliamentary party to push it through. Yet, we have an organization paid by the public to give him and government such information. And that is where the problem is. We have a dysfunctional National Intelligence Service that has exposed the President, the government, and the people of Kenya. Had the National Intelligence Service briefed the President 2 months ago about how the people of Kenya feel about the Finance Bill 2024, so many Kenyans would not have died. Property would not have been destroyed. Offices would not have been touched. There would have been no mayhem. But they slept on the job. It had to take people to die, property to be destroyed, protests across the country for the President to know the truth of what the people of Kenya feel. Yet, there is an organization paid for by the public to brief the President and the government about the feeling of the Kenyan people. Officers of the National Intelligence Service, officers of the National Police Service have told me in confidence they did not get advance intelligence briefs about the magnitude of the protest in Eldoret, in Kericho, in Nairobi, in Githurai, in Embu, in Nyeri. Since independence, there has been protests around Parliament. Never have protesters invaded and gotten inside Parliament. Senior officers have told me in confidence they did not have an advance intelligence brief about the intensity of the protest so that they prepare in advance. The National Intelligence Service slept on the job. And the problem is simple. The Director General of the National Intelligence Service, Nuruddin Haji, was a junior officer in the National Intelligence Service before he was appointed as DVP. When he was appointed to the office of the Director General, because of inferiority complex, he chased away all the people who were senior to him when he was in the service, therefore crippling the capacity of that service and making it dysfunctional. 3 directors were chased away and reassigned to desk jobs in ministries.
Mr. Speaker, sir, we can pause it at that because of time. We've captured the parts. Now, Honorable Mutuse, the Deputy President recently addressed a press conference where he rubbished this allegation. He said it's pure hogwash, nonsense upon stilts. What is your specific complaint against the Deputy President in this allegation?
2 specific complaints. 1, the Deputy President is a member of the National Security Council. And if he has any complaints against the National Intelligence Service,
yes,
who also sit in the National Intelligence Council, he can raise those concerns there. So that we promote institutional leadership.
You mean the National Security Council?
The National Security Council created under Article 240 of the Constitution.
Yes.
And the Deputy President as forum. And like all other ordinary citizens, senators included, as we can complain out there because we don't have an official institutional forum. The Deputy President as forum where he can raise his concerns. Number 2, this was a time of monumental crisis in the Republic of Kenya. And the statements were sensational and they would have made Kenyans to believe that our security organs are not functional and would have easily led to citizens running amok and the Republic getting torn apart and our national fabric getting destroyed completely. But even more importantly, I had learned counsel Ongoya refer you to your oath of office. And I would wish that he also refers his client to the oath of due execution of office that he did swear. In the oath of due execution of office that the Deputy President took on ascension of office, it states as follows, that I will not directly or indirectly reveal such matters as shall come to my knowledge in the discharge of my duties and committed to my secrecy, emphasis, secrecy. He has said in the clip that we have played that officers of the National Police Service have told him in confidence that they had not received advance intelligence reports. That is what was contemplated by this oath of due execution of office. What Senior Counsel Orengo called addressing fears. That if a matter is committed to you as a state officer in secrecy, it must remain in secrecy. If you take it to a public press conference, then you have gone against your oath of office, and that is an impeachable offense.
This oath of office that you say the Deputy President takes, is it anchored in any clause of the Constitution?
Yes, the oath of office is in the 3rd schedule of our Constitution and therefore part of our Constitution.
Can you read Article 148(5)(a) of the Constitution?
Even to begin with, under Article 74 of the Constitution, before assuming a state office, acting in a state office, or performing any functions of a state office, a person shall take and subscribe the oath or affirmation of office in the manner and form prescribed by the 3rd schedule or under an act of parliament.
Okay. And what about Article 148, paragraph 5A? What does it say?
Article 148, paragraph 5A?
Yes.
It says the Deputy President-elect assumes office by taking and subscribing A, the oath of affirmation of allegiance, and B, the oath or affirmation for the execution of the functions of office as prescribed in the 3rd schedule. So it is a constitutional issue.
Finally, the Deputy President in his press statement the other day, he said, even in other countries, the US, stable democracies, it's not uncommon to see heads of intelligence institutions being attacked or criticized by public officers. What is your comment about that specific remark?
Even in our country, it is not uncommon, but it depends on who is doing it. The Deputy President of the Republic of Kenya cannot behave in a manner that disparages the institutions of the state that he was elected to superintend, especially so when he has official institutional forum to raise those concerns.
Is there a forum where the Deputy President can conveniently raise these issues without undermining public confidence in the security system and public trust in these institutions that are paid by the taxpayer?
I have said earlier, under Article 240, the membership of the National Security Committee is number one, the President, and number two, the Deputy President.
Okay.
And the National Intelligence Service is a member, and therefore that can be canvassed behind closed doors in a formal way and a decision made so that we do not break down our institutions, instead we empower them.
Which article of the institution are you referring to? Where the National Security Council is established?
Article 240, if my mind serves me right.
Okay.
And we can read it if we have time.
The other explanation by the Deputy President is that these agencies are accountable to the civilian authority and therefore not immune to criticism.
Article 240, establishment of the National Security Council. There is established the National Security Council. The council consists of the President, the Deputy President, so is a member by dint of Article 240.
Okay, okay.
He says they are subject to civilian authority.
Yeah.
Because of Article 1.
Okay. Yeah, because of time, let's go to the last allegation. Last allegation. That's ground number 11. Are you there?
Yes, I'm there.
Okay. Can you explain to the senators your specific grievance about this ground?
It is we are saying that the Deputy President has committed gross misconduct by bullying state officers.
What's specific ground on that gross misconduct that you
we are saying that
take into consideration?
His Excellency Gachagua bullied Kenya Medical Supplies Agency officials into awarding a tender for the supply of mosquito nets to Crystal Limited, his proxy company, that it submitted an irregular bid bond with the sole intention of fraudulently acquiring public property. That His Excellency, and basically in relation to KEMSA, so that we can paraphrase. KEMSA advertised a tender funded by the Global Fund, which is one of our major development partners in terms of delivery of healthcare in Kenya.
Yes.
The tender was valued at about 3.7 billion. At the time, the procurement process got botched up, and Senate would take notice that at that time, the peers in charge of public health and the CEO at KEMSA were dismissed by His Excellency the President.
Yes.
And then an acting CEO was appointed, and the acting CEO also saw an affidavit to this regard. And the problem here was that there is a company, an Indian-based company, called Shobika.
Shobika.
And Shobika, because we have been told we are bringing in a company that was not part of the tender. In the evidence of the Deputy President, this company called Shobika is represented locally here in Kenya by a company called Crystal Kenya. And that is by the admission of the Deputy President himself in his own response. And Crystal Kenya is the company that we have demonstrated all the way from Nyeri to Malindi to Kilifi, that is the major special purpose vehicle that the Deputy President has been using to acquire property and to launder money. So this company is as an agency agreement with Shobika to represent them locally. And what happens, the evidence that we have placed on record is that when Dr. Andrew Molo is appointed the new CEO of KEMSA, at that time, investigations are going on into the irregular procurement of the 3.7 billion mosquito nets. And then one of the issues of interest in that tender is how Shobika submitted their bid bond, because the main complaint was that they submitted their bid bond outside the tendering period. So when investigations are going on, the Deputy President, who admitted live on television, called Dr. Andrew Molo, the acting CEO of KEMSA, and told him, I have sent my people, please give them that bid bond. And he said he did it because the people were wondering. And then we have annexed messages, WhatsApp, excerpts, in the affidavit of Dr. Andrew Mulwa that is contained on page 67 to, in the volume, if you go to volume 1, page 67 to page, all the way to just briefly, so that we are factual. All the way to page 77, we have annexed the affidavit of, the witness affidavit of Dr. Andrew Mulwa.
Okay.
And on it, we have also exhibited SMS messages.
Honorable Mutuse.
Yes.
I think we've seen the affidavit. You've said it's at page 67, eh?
Yes, page 67 of volume 1.
Yeah, and you've said the deputy president interfered with this, attempted to interfere with this tender process, eh?
It is the evidence.
Where is that evidence so that we can conclude our testimony?
It is the evidence of, on oath,
yeah,
of Dr. Andrew Mulwa.
Is that the one at page 70?
If I read, and Dr. Mulwa is available for purposes of this, he says, on or around 11th July 2023, His Excellency Rigathi Gachagua called me from his mobile phone number, and he has given the number there, on my mobile number, and the number is there. This is on page 68. On my page 68, volume 1. Page 68, volume 1, paragraph 4. On my mobile number, and pressured me to surrender to his proxy the original bid bond submitted by Shobika Impex Limited for the above tender. He told me that he would send a proxy to collect the original bid bond. He goes ahead to state, Dr. Ikino Rigathi, His Excellency Rigathi Gachagua's son, called and sent a WhatsApp message from mobile number indicated, claiming to be acting for and on behalf of His Excellency Rigathi Gachagua's. He asked for.
Honorable Mutuse, where is that WhatsApp message exhibited so that we can end up?
Go to page 70.
Page 70.
Go to page 70.
Page 70 of your volume.
You will see WhatsApp messages that are exhibited.
Okay.
From the phone of Dr. Ikino Rigathi.
Who is Ikino Rigathi?
Is a son to Rigathi Gachagua, and the message says as follows. Hello, Dr. Ikino Rigathi here. Kindly contact me when possible. There's a document for HE. HE is the short form for His Excellency. We are trying to collect. He was not collecting his own document. He was not collecting,
so we can stop there.
A public document. He was collecting a document for HE.
We can stop there, Honorable Mutuse. Now, finally, Honorable Mutuse, have you sworn an affidavit to support these allegations against the Deputy President?
Yes, indeed. I saw.
Where is this affidavit in your?
In volume 1,
yes,
of our bundle of documents, at page 41, page 41 of 85, page 41 all the way to page 43 is my affidavit in support of all the grounds of impeachment against the Deputy President.
Thank you very much, Mr. Speaker, sir. Because of time, we want to request to end our examination in chief for this witness. Thank you very much for your indulgence and accommodating us.
Now, how much time is remaining out of the 3 hours? So, Counsel for the National Assembly, you have 45 minutes to conclude your case, to do re-examination and call the other witnesses and do re-examination in 45 minutes. That is the time remaining. Now, Counsel for the Deputy President, you have 2 hours in total for cross-examination of all witnesses that will be presented. So you may choose to use all that with this witness, or you may decide on how you're going to apportion it. You may now proceed